Well, thank you for joining me today, Skye. We've got Skye Owen here, who is Senior Associate at Family and Relationship Law Group, which is Lender and Rogers in Sydney. Is that right?
Yes, that's right. Yes.
Excellent. I had to get that right. Now, Skye and I have known each other over many years because we've lived near each other, and often we've talked about some of the things that both of us experience with going through divorce or settlements. Being an advisor, I see that on the financial end, usually after the come and seen, sought legal advice. So I thought this would be a great opportunity to have a chat with you and ask some questions, because a lot of people, don't get married to actually get divorced,
No.
but so we often have no idea what the process is. Hang on, I'm just going to turn. I don't know if you can hear that, but my assistant's talking to me through. I might have to start again. Can I just tell her to stop? I have to start again.
Okay.
Start again. Okay. Well, hello and thank you for joining us. Today we have Skye Owen, who's a Senior Associate at Family and Relationship Law Group, which is Lander and Rogers in Sydney. Skye and I have been friends for many years and often have conversations about, the settlement process, the divorce process and whatnot, given often I deal with divorcees coming to me for financial advice after the fact of settlement, sometimes beforehand, and I've got to recommend they go see someone or seek advice. And you're often, in the coalface dealing with that situation. And there's a lot of people that have a lot of questions around this conversation. I get a lot of people come to me and go, where do I start? And we don't get married to get divorced. So there is sort of no clear direction on how to go about this when your relationship implodes in some way, or you're at that crossroads and having to look down at how do we divide up our assets, how do we split this life that we've built together. So I guess the first part is, where do people start when they are looking at considering even separating or divorcing?
Mm-hmm. Well, I guess the first thing I'd say is that family law doesn't just affect people who are married, it also extends to people who are in de facto relationships. So it's important to know that if you're living with someone and you separate, then you also may need to also see a family lawyer. And I think from my experience, if you are going through a separation, it's probably good to get advice from a lawyer who has experience in family law relatively early on, just so you know what your entitlements are, and you can get a good feel for how to progress the matter as smoothly as possible, because our goal as family lawyers is to try and keep people out of court. That's what we want to do, because the family law system is so clogged at the moment. So I think if you're going through a separation in a marriage or in a de facto relationship, then getting some advice from a qualified family lawyer relatively early on is what I would recommend.
Good advice. So the concern people often have is the expense of going straight to a lawyer. Are there, and I think your advice is great, because it's just you want to keep people out of the court system. So a lot of people have this concept, if I go see a lawyer, that's the next step. So can you talk us through what the process is when someone comes and seeks advice? And, is that when mediation kicks in, or how does all that work when you're sort of beginning stages?
Well, in financial matters, because as lawyers, as family lawyers, we deal with parenting as well, but I'll keep my comments to financial matters for the purpose of this discussion. If a client was going to come and see me in relation to a recent separation and they wanted to talk about financial matters, the first step we would be saying is that we need to get full and frank financial disclosure to actually work out what there is to divide in a property settlement. So that would require our client who comes to see us getting together all their financial documents, as many as they have, including tax returns, bank statements, superannuation forms. And then we would either advise them to ask their former partner to provide those documents to them, or we would communicate with their former partner directly and say we need to get those documents. That would be the first step. The second step, once we actually established what there is in terms of property, bank accounts, superannuation companies, trusts, those types of assets and liabilities, we would certainly, as far as we can, be proposing a mediation if all of those assets and liabilities, the values were agreed. So often there can be disputes about the value of certain properties. So, for example, there might be a house and partner A says it's worth $200,000 and partner B says it's worth $1 million. And in those circumstances, you would either try and meet in the middle and come to an agreed value, or you would jointly instruct a valuer to give you a value of that property, if of course the parties are wanting to keep the property and not sell it, because if you were selling it, the market would decide. So it's important that the values of all the assets and liabilities that are in the balance sheet, in my view, are agreed before you actually go to a mediation, because if there's a dispute about the value of any of those assets or liabilities, it can make settlement discussions very difficult. So we would be helping guide our clients through that process of getting a settled balance sheet. And provided that all goes smoothly and both parties are cooperative in that process, then definitely we would be referring them to a mediator to try and resolve it on a final basis. And mediation can occur with or without lawyers. So there are lots of mediators we can send clients to that don't necessarily require it to be a lawyer-assisted mediation. Often in property settlements are a little bit more complex. It might help to have a lawyer present, but we can often guide in the background, but we can also be actively involved in the mediation process. But definitely mediation is the way we would be progressing a matter as quickly as we can. The thing I should mention just on that point, and I think it's important that I raise this, is in family law matters, it's not just property settlement. So people often forget that in terms of financial matters, there's a thing called spouse maintenance. So we often have clients that come to see us who may never have worked during the relationship, or they may have the full-time care of young kids and they can't work. And it's been the pattern throughout their relationship that their former partner supports the family financially. They've got quite a traditional family model where, you know, mum's at home with the kids and dad's at work. And then they separate and all of a sudden mum can't support herself any longer because she's got no income coming in. Her former partner's cut off the financial support. And she can't meet her expenses. And in those circumstances, she may be entitled to what we call spouse maintenance. If she can establish a need to be supported and her former partner has a capacity to pay, then there may be a spouse maintenance. She may be entitled to spouse maintenance. So separate to property settlement. So we would be giving advice about spouse maintenance and property settlement. They're two different areas. So it's important that people are aware of that, because often they're not.
Yeah, and that's actually quite a scary thing for somebody who, say, is in a relationship that they're incredibly miserable in, and they know that there's no end to that, but having to leave, especially with young children. And the fear is, how am I going to survive? How can I get through this? And, you know, then there's that element of potential control of having a partner that has looked after everything and then gone, no more. That would actually hinder the process for someone to even leave. And we talked before we started recording about financial abuse, and I've interviewed Amanda Casser on the topic. So I would like to talk a bit about that as well later. But have you come across cases where it's taken a long time before the partner's actually gone, I've got to get out of the situation, I need to end the relationship?
And often we'll have clients that come to see us even before separation, saying, this is my situation. I'm really concerned about how I'm going to manage. What do you recommend as the best way for me to get out of this relationship, but be able to survive financially in that transitional process? So I think that it's important, I should also throw into the mix there, I like to think of these as family law bubbles, and I have to thank my colleague Tessa Kelman for this concept. I can't claim it as my own because Tessa talks a lot about family law bubbles, and I think this is an important concept. So in one bubble, we've got property settlement, which is when we're looking at how we're going to divide what's in the pool. So the assets, the liabilities, the superannuation, the company, how that's going to be divided. In the second family law bubble, we have spouse maintenance. So how am I going to survive, given that I haven't worked for such a long time, and how am I going to survive? And that's talking about support of the spouse. In the third family law bubble, we have child support. And that's important because in Australia, both parents have an obligation to financially support their children. So you can have either a private child support agreement with your former partner where you agree to pay, he agrees to pay a certain amount, or you agree to pay a certain amount, and you both agree to contribute to other expenses such as school fees, health expenses, all those types of things that children need. Or you could do it through the government system, which is through the child support agency, where you file for an assessment through the agency, and then there's an assessed amount that has to be paid for support of the kids. So that's an important thing when you're looking at separating, knowing what exactly you're entitled to and how you're going to manage. So I do see a lot of clients who have been in very financially abusive relationships, and it has really affected their ability to feel like they can separate and leave that relationship. And so we'll give them advice about how things might look moving forward. And we'd also often refer them to people like yourself to get some financial advice as to how this is going to look when they're on their own and they don't have that regular money coming in. It's often not that regular. So I've had clients that, you know, maybe given an allowance and it's not very much money. So that's the type of financial control we see.
Yeah. Have you got an example? Like, going on the topic, because
Yeah.
probably with last week from this recording, we'll have had Amanda Casser on. So it's a nice segue to actually get you on and continue that conversation of financial abuse. Have you got any examples so people can kind of go, oh, recognize in themselves or potentially other people? Because I think this is something that not many people are very aware of, but it is so, it's out there and it's so prevalent actually. I mean, I've seen it here as an advisor. I'm sure you've seen it many times over as a, you know, as a lawyer, it's all over the place, but it's not talked about. And something that I think we should be shedding more light on. So if you don't mind, can you share some examples? That'd be really great.
I had a client, because I've been, we were discussing this earlier, but Landra and Rogers are very supportive of different pro bono initiatives. And one of those is a pro bono secondment, which I currently am doing one day a week to the financial abuse service at Redfern Legal Centre. And this is a statewide service that's helping predominantly females have come out of relatively financial controlling relationships, helping them try to manage post-separation. So I would provide legal advice. There's a credit and debt team that help provide advice in relation to liabilities and debts. So I've been working there one day a week, and so just thinking of some examples of the types of matters that we get. One matter comes to mind. It was a matter where I was advising a mum who had a couple of really young kids. So they were very young. She hadn't worked for a long time, and that was agreed with her former partner. He had encouraged her to stay home. Initially, it all was fine. She was happy to do that. And she was also helping to raise his older two kids. So he had two older kids from a previous relationship. So she gave up a relatively highly paying position to stay at home to support his career, to help him raise initially his older kids and then their two little kids. But over time, her independence, her financial independence sort of eroded. And eventually she was completely dependent on him financially. So, for example, she'd have to justify every expense that she made. So she bought a coffee, she'd have to explain why, where, who with, when, this type of control over her everyday expenditure. So initially she'd be paying for things on credit card, and he'd go through the statements and query at the end of every day exactly how she'd spent every cent out of the account. It then transitioned to a point where he would only give her a set amount of money each day that she could spend, and she had to provide receipts to show how she'd spent that money. And at the end of the relationship, she was given an allowance of about $10 a day. And that's all she had to spend. Everything else, he would control the expenses. So he would pay for the food. So she had the water, the electricity, everything. She had no control over any of that. And she just couldn't handle it anymore, rightly so. It was just so controlling of her every minute. So she left the relationship and had these two little kids, and he refused to pay anything. So she was living in a hostel for a while because she couldn't afford to live anywhere else. And anyway, we provided her with some advice. We were able to help her through that process, and eventually we were able to get her back into the home, which was important because she needed to be back in the home and him out of the house with paying the expenses, so she could actually have some semblance of control over her situation. But what was important in that case was we ended up getting him to pay a periodic amount to her. So in addition to paying all the expenses for the house, the outgoings, and some of the kids' expenses, he also was paying her a periodic amount each week, which gave her a bit of control over how she was spending her money. And she knew how much she had, she could budget, rather than paying for everything on credit, and then he could still keep control of what she was doing and where she was going. So I think that was important for her, that she had that periodic amount coming in. But that's just an example, and it's probably an extreme example, but I think it's the type of case that we see a lot of. I think financial control is very prevalent. I don't even know often whether the perpetrators of financial control are even aware of what they're doing in some of the cases that we see. Sometimes I don't think it's even intentional. It's under the guise of budget or trying to be financially responsible, but it has a flow-on effect, in my view, of being controlling. And the other thing we were talking about, Amy and I were talking earlier, was about how often clients don't even know the level of liability or debt that they're in during the relationship. Yeah. And it's as though they've got their head in their sand. It's just they honestly don't know. They trust their partner. He has control of the finances. They'll just sign that document and not even question what they're signing because they trust that, you know, this is a family decision. And then when they leave the relationship, suddenly they're up to their neck in debt, often in their own name, and trying to get out of that and unwind all of that is very difficult. So they're just some examples of the types of things that we see as family lawyers, and trying to unwind that requires a bit of help from people like yourself.
Yeah, look, I've come across that as well. As a financial advisor, I try and encourage both parties, you know, husband and wife, or, you know, the partners, to be in the meeting and to be involved. And I ask, you know, questions about how they feel about things and are they understanding. And when I set up the, you know, sort of, not a budget, I don't like to call it budget, the lifestyle plan and their banking system, I ensure they have their own bank accounts, they have their own spending, that they've got that sense of autonomy, you know, over their finances. It's important that we have that. It's a part of being, you know, having that self-worth and knowing that we have that control. And if, you know, if I've come across anyone that has been in that situation, it's usually the older generations, because
yeah, that's right.
And when we're talking about, you know, a partner who's, you know, in your case, I'm thinking the husband may have not deliberately started out like this as to be mean or to be controlling and to be that tyrant, but they've been raised in a way that this is what they've mirrored from their parents. And that's something I've learned with the training I had with money coaching, is we look at the past, we look at the childhood, we look at all these things, because that all comes up when you're as an adult, and we start behaving the way we were taught. So, you know, abuse usually comes from other, you know, it's multi-generational. It's not just coming out of a new method of managing the money.
No, that's right. I think that's right.
Father have been doing it as well.
Mm-hmm. No, that's entirely, I think that's right. And that's why I had to make that point that often this type of control is really not intentional.
No, and that's something that Amanda brought up in our podcast. Is she said a lot of the time when it's that they've not realised when it's recognised that there's some kind of in a financial planning meeting, for example, where you're starting to see, oh, you know what, you're making all the decisions. How do you feel about that? Well, actually, I think I'm quite uncomfortable about that. Okay, and then they've gone away and gone, oh, sorry, I didn't realise that was how you felt. So having these open conversations early in the piece in a relationship about money is actually quite a healthy thing. And that's why I wanted to do these podcasts, was to bring the conversation of money to mind on a regular basis in all sorts of industries. And obviously when you're in the hot water, where you're finding, people are often, when they're needing that help, when they're coming out of a relationship, it's sort of a bit too late. But at this point, it's now about educating or re-educating and helping people find their way out of that situation or finding a new path out of the relationship. That sort of leads me to another question that I've been thinking of, and the one that I've had with divorcees when they go, is this fair? What is the best outcome for me? What can I get? Or especially when it comes to superannuation, how much would I be entitled to if I were to separate? What would that be? What does that look like? I mean, it is an open-ended question.
Yeah, it is.
It's quite a loaded question. But have you got some ideas or examples or ways of working things out for people that then creates a fair outcome?
So we all have to follow the legislative pathway in terms of how we approach property settlement. So what that means practically is there's currently a 5-step process that as lawyers we need to follow when giving advice to our clients about likely range of entitlements. So what I should say from the outset is family law is incredibly discretionary area of law. So you can have 10 different judges, 10 different lawyers who all come to 10 different decisions or views in relation to what a person may or may not be entitled to in a family law property settlement. However, that's why we talk about range of entitlements, because generally those 10 different judges or 10 different lawyers will come to a percentage that's within a range. So you might say 50 to 60% or 55 to 65%. And generally they'll come to a percentage figure that's within that range based on different facts in different cases. So if I can just rewind back to the 5 steps, the first step is, should there even be a settlement? Is it just and equitable that there be a settlement? And in some cases, if it's a very short relationship, there's no joint assets, it may not be just and equitable that there be any settlement. So the first hurdle you've got to get over is, should there be any settlement? Most cases, generally, yes, there should be. And in most cases, most parties will jointly agree that, yes, there does need to be some adjustment of the assets and liabilities. But just need to be mindful that in family law, that's the first step, whether there should be any adjustment at all. The second step, which I sort of alluded to a bit earlier, was what there is to divide, what is in the pool of assets that are available for division. That includes all property, houses, cars, household contents, bank accounts, shares, superannuation, business interests, any trust interests, all of that is included, and as well as liabilities, so credit card, personal loans, mortgages, all of that goes into the pool of assets that are available for division. And that is what we call the first step, is the full and frank disclosure, where each party exchanges financial disclosure so we can work out what there is to divide, whether there needs to be any valuations of assets to establish their value. That's the first step. Once we've got the balance sheet, we can say, well, now we know exactly what there is that has to be adjusted and what there has to be divided to end up with a property settlement. Once we've got that, we can then say what the third step is in a property settlement. The third step is looking at each party's contributions, both financial and non-financial, during the relationship. So we'd initially say, well, what did they each bring in? So what were their initial financial contributions? So maybe they both came in with nothing, and maybe that one party came in with a lot and one party didn't have a lot. But we look at initially what they've both brought into the relationship. Then we look at the financial and non-financial contributions that they've each made throughout the relationship. And it's important when I say this to know that if one party's working and one party's at home, non-financial contributions at home are equally as important as financial contributions outside of the house. So I don't like to say, oh, you're just at home. It's important to say that person's actually working in that role at home. They're a homemaker role, and that is treated equally by the law. So we're looking at financial, non-financial contributions during the relationship. Then we look at financial and non-financial contributions post-separation. So what have these respective parties done post-separation? Has one party continued paying the mortgage and meeting all the outgoings on the assets? The other has done work to the property in terms of maintenance, renovations. Has one party been primarily caring for the kids, doing all the homemaker work? We're looking at all of these different contributions. At the end of that process, we'll come up with a percentage figure and say, well, on the basis of the fact that you came into the relationship with nothing, you both worked equally financially and non-financially during the relationship. Since separation, you've done the same. There might be, in our view, it's 50%. So you're both worth 50%. Or he brought in a house and that's added significantly to the asset pool. Therefore, he should be given some type of credit for bringing that in. Perhaps, he gets 60% and you should get 40% in our opinion. We come to a very discretionary view as to what the percentage on contributions is, looking at all those facts, which vary significantly from case to case. Once we come to a percentage, in our view, on contributions, we look at future needs factors. So things like, is he going to be earning $500,000 a year and she's going to be at home looking after the kids, and her earning potential's been affected by all the years that she's been home with the kids? Or he's got an illness that means he can't work and she can work, and therefore his earning capacity into the future is going to be affected by that health condition. We look at all these different future needs factors, and then we say, well, perhaps there should be, on the basis of the earning disparity or the health condition, there should be a further adjustment in one or other party's favour. And that means that whilst it might initially be 50-50 on contributions, one party might get more on the basis of their future needs. Once we've gone through that whole process, the final step is this outcome just and equitable? And that's generally looking at not only is the whole overview percentage just, but is the mix of assets just and equitable? For example, is one party keeping more of the super assets than the other party? Or is that appropriate? And that might be appropriate in circumstances where we've got one party who's earning a lot more. Perhaps they should be keeping more of the super assets because they can make up the non-super assets in a shorter amount of time than the other party who might not have that earning capacity. But that's what we'd look at in the final step. What exactly is just and equitable? And that's the process that the court has to follow when making a determination about property settlement. And it's what we as lawyers have to apply when advising our clients about what we think their entitlements are in a property settlement. So it's almost like saying, how long is a piece of string? I know that it doesn't really help, but it helps to hear what the process is when we're giving that advice, because I think what I'd say to clients generally when I first speak to them in a property settlement matter is to say, can come back to me with your instructions as to the history of your relationship. So look at what you've brought in, look at your contributions, and give me a bit of a summary of that, because that helps me giving them advice about what I think they might be entitled to.
Well, that's actually a really good answer, because there is so many factors to consider, but the process is, well thought out. I mean, I've had spoken to 2 guys recently. Both have put off the finals, like doing the settlement divorce process. So they're in new relationships, and their partners are frustrated because they've got this financial and emotional and this tie to the past relationship, and the fear that's holding them back to move forward with that settlement is, oh, she's going to take all my super. But both guys have said that, oh, she's going to take my super, I can't. And it's like, well, and I've said similar to, because we've had this conversation before, it's like, well, actually there's a lot to consider about that, and there's a lot that the legal teams would actually look into before that is the case. And that's really, your answer was great, because a lot of people don't think, oh, they're just going to take all this money. Look at her future earnings, and whether she can then, the kids are older and be able to catch up, and vice versa, and all that kind of thing. But I really like that answer. I think that it does sort of debunk some people's theories, because people do think that it's the
most people do.
Yeah,
I get that all the time. He's going to get half of this, or she's going to take half my, this, and it's not. Unfortunately and fortunately, it's not as straightforward as that.
Yeah, but it sounds like, given there is so many factors that is considered, and the fact that they are all considered before you come up with that final, say, percentage or that a figure, is that there has been a massive consideration, and that there is some fairness around that. And it isn't like she's just going to go for everything I own.
No.
When we hear that, I think maybe that's from movies and the US system, just sort of that may happen overseas, but it's good to know that there is actually a really transparent legal process here in Australia that actually are looking after everybody, involved, as inclusive, and as important is the kids. That they're going to be looked after financially in both households. And that, because at the end of the day, and something that we've got to consider with the financial outcomes if you do have kids, is that no one's going to be worse off at the end of the settlement process for the children in that respect. I guess
we hope not. We hope not.
Have you seen any cases that have been unfair?
That's a difficult question to answer.
Okay.
Because because I worked, before I was a lawyer, I worked for a long time in the court. So I worked as an associate to a judge in the Federal Circuit Court. And the judges try very, very hard to apply the law in a fair, just and equitable way. I think, in my view, the unfairness flows from the cost of the proceedings, both emotionally and financially, particularly for that very small percentage of cases. And I say small percentage, I mean a very small percentage of cases that actually go all the way through the court system to a final hearing. What I think is heartbreaking for litigants is at the end of the process, when their legal fees outweigh their entitlement, and you think, what are you doing, and how did you get to this point? As lawyers, in my view, we have a very, very big obligation to our clients to give them advice along the way as to how the matter's proceeding, and often that's frank advice. And I think that we have an obligation to keep their fees down as low as we can. That means going through alternate dispute resolution processes to try and mediate matters, to try and resolve them, to think outside the square often, to come up with practical solutions. But I think when you say to me, have you seen any unfair outcomes? I think the unfair outcomes, in my view, are the ones where the emotional and the financial toll are significant and outweigh the benefit. And I say this to my clients all the time, every day. There's no winner or loser in family law matters. It's just it's just, well, actually, there's no winners really, because in my view, sometimes there are losers.
Right. Wow.
Particularly if when you look at the financial and emotional toll that litigation can have, and regrettably, often the losers are the kids
Mm.
because their parents are in conflict, and that's never good for young kids. So my view is stay out of the system, get good advice, and try and settle matters as quickly as you can.
Yeah. Okay. So that goes back to what we spoke about in the beginning of this interview. Is the first thing is get, as soon as you see the writing on the wall and the relationship's coming to an end, seek that legal advice immediately and start the mediation process to get to avoid that going through to court.
Yeah.
What other professionals do you work with in regards to this whole process?
Accountants often. I work a lot with mediators, financial planners, sometimes tax lawyers, because often settlements have quite significant tax implications for one or other party. In parenting matters, I'll often work with therapists. Even in property matters, sometimes you can refer people to family therapy to get some assistance with their communication, particularly if they've got kids. Whilst the children might not be an issue, sometimes the financial matters can impact on the parents so significantly that it does have a flow-on effect to the kids. So I work quite closely with a lot of therapists. I think they'd be the main types of people that I'd be working with. And often we work with them quite closely during the course of a matter.
Right. And what I'm just sort of randomly asking questions. My mind's going in now because I could talk all day on this because I find this hard. I've been through a divorce, but luckily for me and my ex-husband, we let's just walk away with what we came in with, sort of thing, which at the time really wasn't that much. And it was, you keep your super, I keep mine. And we were focused on about the care of the kids, and we've still, but to this day, that's one thing I'm glad about is our relationship was never, we've sort of put all our disputes aside when it came to the kids. And we're still like that. Kids come first. And it just helped us get through what could have been a very ugly situation in our life. But I've also got a lot of friends and, clients. As I said, I deal with a lot of divorcees, mostly women, that have come through this quite scathed. So I've been lucky to come unscathed. What have you got an example of a really good? I know you said there's no win, and I respect that because as we don't enter into a marriage to be divorced, you don't build your life to buy property to then have it, split or argued over. But what is probably a good example of a positive outcome from a settlement point of view? Have you got any examples that you've actually seen or worked on?
Yeah, look, I think I should say, when I say there are no winners, I mean in litigation. So when you're actually in the court process, a lot of our work involves helping clients settle matters outside of court. That's what we do. We try and resolve matters quickly outside of court with the assistance of mediators. And in those cases, I think that, most clients are generally relatively happy at the end of that process because, they've got a pretty good settlement, minimal legal fees, and are able to get on with their lives, generally with their emotions and their relationships relatively intact. So what I think the problem with court is that it's very adversarial. So it puts, party A against party B in a very confrontational, conflictual way. You've got to swear affidavits that point out all like the problems with your former partner, and no one likes to read negative things about themselves, and so you end up hating each other just by virtue of the adversarial nature of the process. So I think looking at positive outcomes, sure, we definitely see people that think that the process has been quite positive. particularly when it's before court. So if they get out of something, settle it and get out early, I think that's generally when we see the positive cases. I sometimes get clients that have separated, have gone to see a mediator before they even see a lawyer. And in some cases, that may be appropriate. And then they come to me and say, look, we've reached this agreement. Can you help us draft some orders to reflect our agreement? Or can you help us draft a child support agreement or a binding financial agreement to set out the nature of the settlement? And we can do that definitely. We will, of course, provide advice and say whether we think it's a good deal or not, or whether we think it's within the range or not. And can I say, generally, when clients see very experienced mediators, the outcomes are within the range, because the mediators are very familiar with the law that needs to be applied as well. So we'll help them with those, and that can be quite a straightforward, uneventful process. I've had clients that I've never even met face to face. I've just spoken to them over the phone, where they've rung me up and said, look, I've reached this agreement. Can you help me with it? I get a bit of background, I get their instructions, I give them some advice, and then I help them with the documents, and they can be in and out relatively expeditiously. And then they leave thinking that actually wasn't too bad, and now I can just move on with my life. And my relationship generally with their, the relationship with their former partner is generally relatively unscathed through the process. Can I say though, those cases, I think they require a certain level of respect between the former partners that sometimes we don't see, and that's difficult when we've got cases where, and also often there's probably not any family violence in those types of cases. They're much more cooperative cases. But we can also, I guess, try and help people through a process even when there are problems like family violence or financial control. We can also guide them through that process, trying to avoid court as well, because I do think court is a trigger point for a lot of people, and is almost like the path to no end, really, or no good end, but sometimes it's necessary as well. So I think for me the best outcomes are the ones that you can resolve relatively soon, quickly.
So the message I'm hearing more than anything, and quite loud and clear from you, is seek legal advice as soon as possible, or find a great mediator. I would say probably get on the phone if you to someone like yourself first, and maybe get referred to that mediator.
Yeah, they've got to be mediators that have experience in this particular area. I think you're right. I think having a good mediator can help.
So that is actually where the win-win is, when it can be kept out of court, that it's a fair process and it's a quick process, and it's not going to cost the world in legal fees.
That's right.
Because, I mean, as you said earlier, going to court, the sad situations are when the cost is actually outweighs what
they get,
the settlement, which is terrible.
And then they hate each other forever.
Yeah, well, I mean, look, it's a hard situation to go through. You also, you mentioned there's counsellors and whatnot that are available for going through divorce. Divorce is a tough time emotionally, as it is. Throw in the stress of finance, throw in the stress of actually legal fees, and add, fuel to the fire and throw you back into court. That's when it would be quite ugly. So everything,
and it's important that, in my view, most people going through this need some of their own therapeutic support through it. Even in a relatively cooperative post-separation relationship, it can be quite stressful, even if it's just someone that they touch in with every now and again, touch base with and get a bit of support. I think it's really important, and I know myself and all my colleagues often talk to clients about the importance of having that person, or be it a therapist or a family member or a trusted friend, someone you can actually rely on through this process to give some support, because it's really stressful. I feel that with my clients. I know they find this incredibly stressful, and I think just it's important that they do have that support through the process. Um, and I think that's another thing I'd say, you know, if you are separating, make sure you reach out for support because you're going to need it.
Yeah, that's such good advice too. And that sort of self-care is, it's so important. And it's hard, especially when you are going through this kind of trauma. I call it trauma because you don't realize it is until it's over. And I'm speaking from my own experience, but when you've got young children, I know with mothers, they don't put themselves first, and it's really important that they take that advice you've just given and actually look after themselves through this process, because otherwise it just will take their toll on so many other aspects of their life, including their health, where they're no good to anybody when their stress levels have actually affected their not just mental health but their physical health. So
That's
that's
right.
really, really important advice. I really appreciate that you pointed that out. We've just been inundated all over the world with on the internet and social media. Are you okay? I guess that's something that you guys are constantly having to ask your clients through these times. Just on a personal note, do you struggle? Do you find sometimes that heaviness and walk out of your just going, oh, that was just a really
Yeah,
tough time?
I do. I find some days very tough. I think you've got to remain professionally detached, of course, because you've got to be the objective voice as their lawyer. But you do develop really close relationships with your clients because often you speak to them very regularly. You know every intimate detail of their life. You do feel very, very sorry for what's going on in their lives, and you want to try and support them. But I think what I know and what I've learned and what I've experienced is that I have to make sure it's very clear what my role is. And my role is not as their therapist, but as their lawyer. I can't give them that therapeutic support that often they need. And that's a struggle for me because you are in that very close relationship with someone, but you're also a professional, you're their advisor, and you've got to advise within the parameters of the law. So yeah, I do take it home with me some days. I've learnt, I guess, throughout my career that you have to let those things go a bit. So give you time to think about it. You might be worried about something and think, right, well, I'm going to think about this for 15 minutes. I'm going to give myself permission to, ventilate this issue in my own mind for 15 minutes, and then I'm going to move on and I'm not going to think about it again. Or I'm going to walk into the house, and before I walk into the house to see my kids and my family, I'm going to give myself 5 minutes just to wash away everything that I've heard today and go in there with a positive frame of mind, because I don't want, what I've experienced today to impact on my family, because it's important that it doesn't. Unfortunately, with COVID-19 and working from home, that's a little bit
hard.
But I think, I've been around for long enough to know that I think if you give yourself permission to have those worries and have those concerns for a set amount of time and then let it go, that's how I survive.
Right. And that's also really good advice. And I think us advisors are very, in a similar boat in some respects. I have a huge amount of empathy with my clients, especially my divorcee clients, as when they go through that emotional, because what happens after the divorce, after the settlement, is there's this bit of a void, and then all of a sudden that gets filled up with a feeling of loss, and sometimes they actually grieve, and it's okay to do that. But your advice about having that moment and just letting the day wash away before you go and see your kids and everything, I think we all need to take a leave of your book there, because that's really good advice, because we do take on that the emotional impact that our clients are going through. We're human, you're human, and it's important that you have that empathy. What you deal with, you're sitting there with someone who's going through what was going to be the plan of life that's broken. And that's
and they're
what
grieving. They're
yeah.
grieving. Yeah, that's exactly right. It's even I jokingly said before, you know, they'll end up hating each other. I think hate is really, it's a very strong emotion. And I think my old judge, who I think is incredibly wise, used to say, you've got to let go of that negative intimacy. You've got to get through that negative intimacy into a business-like arrangement. And when you can get to that business-like arrangement, then you can get on with your life. And I think that's really good advice. And that's what I talk to my clients a lot about. Because often when you see people that have just separated, they do hate their former partner. They genuinely have that strong hate. And that is not a good emotion to carry in life. It's just not. And so if they can get through that negatively intimate reaction to their former partner and move towards a more cooperative, business-like, respectful relationship, it's going to be much better for both their emotional and their physical health, in my view. So I think that's something to, and that's something that they can work through with a therapist. That's not my role, but it's an observation I make because I think it's good advice.
No, I'm 100% with you on that, and it's something I tend to take on a lot of, that emotional burden, and so I've got to step back and remind myself that I can't carry that burden, that I'm there to give them the guidance like you do and refer on if I have to. So a lot of us advisors go, well, we feel like we're the counsellor and we're the marriage counsellor and we're the, you know, not only the financial advisor and educator and whatnot, but there is a point in everyone's role is to go, there's someone else who's going to be better at that than me. So, you know, you referring that off, you know, is something I've got to practice, but also not take it on. And that's, you know, we're human, but taking it on is so easy to do when you emphasize with your clients. So I'm definitely taking that advice. Going back to, we talked about the first thing. I'm going to go back over what we've spoken about. The first thing you recommend is seek advice, and that be go see a lawyer, someone like yourself, who specialises in this, and then they can refer you on to the right mediator. That's important, not just to go straight into mediation, because I know that people think, well, that's the way to go to avoid the legal cost. That could be causing more problems if you're not getting the right mediator.
Well, it could be, and it could be that the outcome's not just.
So getting the right...
Or it's not ready.
Okay.
Because some matters might be ready to go straight to a mediation, but other matters may not be because the financial disclosure process hasn't been followed. Some cases don't need to follow that financial disclosure process as strictly as others. But it's important that, you know, that you do get advice so you know where you're going and where you're heading, rather than taking steps too quickly. And then you take the steps again, and that adds to the cost because private mediators cost.
Yes. Yeah. So all of this is going to be in some way an expense, but it's by the first step, getting that legal counsel from someone like yourself is actually going to be the most cost-effective process to the beginning of the work, you know, what you need to go through, because you're going to give guidance to, and first of all, listening into the actual circumstance and then guide them based on the information they give you. And then the other part of this is to, you know, obviously avoid going down the road of getting into court. So trying to get that all done and work with each other as amicably as possible. So let go of the anger and just try and deal with it as a business transaction. I think that's being practical. There is going to be a reality of grief and sadness, and often after anger and hatred comes sadness. You know, those steps of grief, and that's okay, and we've all got to be forgiving of it, you know, ourselves for those kind of things. So I want to I think perhaps we could create a bit of a fact sheet of what to, things to consider, just so that when people are getting advice, for example, we go back to how you calculate um, someone's, division of their superannuation with all these considerations. I'd love to put that in sort of a bit of a fact sheet so people actually are armed with some knowledge of going, oh, they're not just going to take all of my super, they're not going to take the house.
No, they're not.
There's so many misconceptions around divorce and settlement, and and how assets are divided.
What might help? We our firm put up articles about different areas of law, like summaries of different areas of law on our website and also on our LinkedIn page. Maybe that might be of assistance. Some of those might help as well. I think probably some in there that look at property settlement, spouse maintenance, those types of issues. That might be a place to start.
Yeah. And before we go, I just want to go back to the pro bono work you're doing with the financial abuse and the refuge. Can you just give people a few, I mean, we did talk about this with Amanda, but I would like you to sort of also shed some light on some things that people could look out for as what could be financial abuse if they're feeling like they're in a bad situation, because often people are already in hot water when they realise it's almost too late. So if you can give us some ideas or insights or even an example, I know we've talked a bit about it, and also just let us know where people can seek help for that if they are feeling that they are in that situation.
Well, I think things like not being able to freely spend money is the key. So I get that even in healthy relationships, there's a bit of oversight as to expenditure. I mean, I can spend whatever I want, really, but if I'm going to spend something big, I would obviously talk to my partner about that. But if you've got to talk, and if you're spending money and every expense is being scrutinised in a way that makes you feel uncomfortable, then that may be financial control. If you feel like you've got no insight into where money is or how it's being spent, or you've got no control over money, that also may be an element of financial control. In terms of who you can see to get support for that, I think financial control, and I think people don't realise this, but financial control is actually a form of family violence. And that controlling coercive behaviour is family violence, is defined as family violence under the Family Law Act. And therefore, if you feel like you're being controlled in a way that doesn't make you feel comfortable or doesn't make you feel like you're being an equal partner treated respectfully, then my advice would be to firstly go and see a therapist or someone who has specialty in this type of area. You can ring, there's a number 1300 RESPECT that you can ring, and the counsellors on that in that call centre can help, and they can also guide you and refer clients to different areas that can help them. So I think firstly getting therapeutic support to manage that is important. If you're looking at wanting to separate, then again I would say go and see a family lawyer with experience in this area. If you don't have money to engage a lawyer, a private lawyer, Legal Aid New South Wales have a domestic violence unit specialising in family law. You can make an appointment to speak to one of those lawyers initially, or you could go and make an appointment to speak to one of the lawyers at the Financial Abuse Clinic at Redfern Legal Centre. That's a statewide service. So, and it's all being done by telephone at the moment. So you ring up and you get an appointment, you say what they'll do an initial intake, and then you can speak with a lawyer as to what advice they might think is appropriate. But I think firstly, you've just got to identify that if you are in a situation that makes you feel uncomfortable and you're not feeling supported, or you're concerned that you don't have very much freedom, particularly in relation to financial freedom or any other freedom really, then you should be getting some support with that. And that, I think, is really important. That's the first step.
And having the courage to ask for that help.
That's right.
Yeah.
And
And I
that's
guess anyone
difficult.
who's listening who recognises maybe a family or friend of theirs potentially in that situation, but don't know how to approach it.
Yeah, it's awkward, isn't it? I had a friend once whose neighbour, she felt might have been in that situation. This was several years ago, when I was still working as an associate, and she didn't know what to do. And in the end, I got her some pamphlets from the court, because we had at the court where I worked, there was a family violence unit at the court, and they had lots of pamphlets about different support services that were available. And she ended up giving those to the friend, and said, look, I think maybe have a read of these. And a few months later, the friend approached her and said that she had actually done that, and she'd finally reached out to one of the support services, and the relationship had broken up. So she was quite thankful for that. But I actually think that's quite brave on two fronts. It's brave on the person giving the information, because it might be met with quite a negative reaction, and it's brave on the lady that left that relationship, because it's very hard to do that, to make that decision.
Yeah, absolutely. Especially if you've got children involved.
That's right. It's not easy. It's not
No.
at all. So I would just say to anyone who's listening today that that it is, if you are in that situation, taking that first step is hugely difficult, and you have to do it when you're ready and you feel comfortable, and don't feel pressured to do anything that you don't think that you're ready for. You have to make that decision yourself.
That's great advice. Well, you've been full of amazing advice today. Thank you. So many great nuggets that we can take away. And I think we've also debunked some, myths about how divorce settlement is calculated and the outcomes, because we do have a very fair justice system here. And there are, people like yourself that actually want to help come out with the best outcome for people, and ensure that they're not actually spending ridiculous amounts of money and ending up dragging their feet through court, which is something you actually want to avoid. I really appreciate everything that you've shared today. And what we'll have to do is get some links on the Sensibility website to your firm, and some information and fact sheets. And also, obviously, if you want to reach out to Skye or her other colleagues, that they can go through either my website, which will have in resources, or it's Lander and Rogers in Sydney.
Yeah, it is. Yep.
Excellent. Thank you so much for your time, Skye.
No worries. Thank you.